One of the things that he has cottoned onto, I think this is the main crux of his application, is the comments the judge made to Cheryl Zondi, that first witness last week, where he told her all the very best of luck with your exams. You go and focus on your studies and, quote, leave it to us. If you were in Peter Daubermann's position at the moment, is that something that might latch you onto the fact that, wait, this judge is not completely impartial?
No, I don't think so. You know, it is a fact that she's busy writing exams, and it is a fact that the judge, after having been presented with all of the evidence from the state and all of the evidence from the defense, needs to make an objective and impartial decision as to whether the accused person is guilty or not of the offences which he's being charged with. And I don't think that that impairs his objectivity in any manner whatsoever. I think that that is a weak argument in support of him having to recuse himself. And the reason why I say that is because the reasons why a judge would have to recuse himself is if it can be proven he is acting in a biased manner towards either an accused person or towards the state prosecutor, or towards a witness, that he has a personally vested interest in either a witness or an accused, or with a defense attorney or any of the parties before him in court, and that impairs his ability to make an objective decision based on the evidence presented before him. And I don't think that there's anything at the moment in front of the judge which could force him to do that.
Okay, what about this statement? In the same comment that the judge makes to Cheryl Zondi, he says, you coming to testify here is not about yourself, but it is in the interests of justice. So what Peter Daubermann is arguing is that presupposes that the witness is telling the truth, that the judge himself is already looking at her testimony as a true version of what happened.
Well, remember that the interest of justice dictates that all available evidence that a judge should be hearing in a matter such as this must be presented. She has done that. She's given her testimony, and she has been cross-examined extensively based on her testimony. And we must remember the purpose of cross-examination. It is to determine whether a witness is telling the truth or not, and furthermore to determine whether a witness can properly recall what occurred on the day or during the incident over which she's testifying about. And that is the only purpose of it. So he should leave it up to the judge to determine whether the testimony led by the witness is truthful, is accurate, and whether it withstood cross-examination. So him saying that it's in the interest of justice for her to testify could also be seen as him merely confirming you did the right thing to come and testify. You put your version before this court. It was tested extensively under cross-examination. You should now leave it up to the court to determine whether sufficient weight should be attached to that evidence or not, and whether the court is going to accept your evidence as being truthful or not. Alternatively, whether the cross-examination showed that you in fact cannot properly recall what happened. You in fact were shown to be a dishonest witness who fabricated the truth, and then the court should attach the necessary weight to that. Remember that all of the witnesses which are called by the state and who present evidence all need to be considered together as a whole, and then the judge must determine whether they contradicted each other, whether their versions supported each other, and whether the judge should be attaching the necessary weight to each specific witness, or whether it was to the detriment of the state's case or not. And I think that that is more what he meant when he said it was in the interest of justice for you to come and testify here. So certainly very interesting to see, always to see an application for a judge or a presiding officer to recuse himself or herself, because remember, you are taking that presiding officer head on, and you are attacking their objectivity and their impartiality. So obviously it's difficult for a judge to not take that as a personal attack upon himself. But at the end of the day, you know, if this matter does run its course and the state finalise their case, and then the defence has an opportunity to present their case, and a judgment is made by the judge, either that the accused people are innocent or that they are guilty, and he convicts them and he sentences them, and this matter is then taken on review by the defence attorney, and it is decided that the judge should have recused himself from the outset, then one could very well see that this matter starts de novo, what we call it, so it starts afresh, and all of the evidence presented would have to be presented once again in order for a new judge to make an objective finding. So the stakes are very high.
Yeah.
It is a very serious consideration for the judge to consider whether fingers can be pointed towards him, whether he acted in an objective manner or not. But I don't think the argument led this morning shows that he's been impartial in any manner whatsoever.
I mean, Ulrich, you started off by saying this is what you think he meant by saying you coming here to testify is not about yourself, it is in the interests of justice. You then went on to explain what you think the judge meant by that. But I'm going to play devil's advocate here and say that's your interpretation, and the extensive explanation you gave of what he may have meant was not what he said in those words. It does give you a sense, in some way, that he was consoling the witness. And the question that Peter Daubermann is asking is it your job as a judge to console a witness? Or should you be sitting there completely dispassionately listening to the evidence that is led?
Well, was he consoling the witness, or was he purely stating that she need not concern herself with the remainder of these proceedings, which is exactly what he said and which is exactly the truth. She has given a testimony. It's been tested. Now, leave it up to the court to decide whether it was truthful or not and whether the necessary weight must be attached to it. So, the same could be asked on the other side is, how does a judge saying to a witness it was in the interest of justice for you to come and testify at all impair his objectivity? And that is for the judge to decide at the end of the day after this application. Yeah.